See if Jeff's ready. I call the special meeting of January 26, 2026 to order at 6 p.m. Will the clerk please call the roll?
Elfers?
Here.
Evers?
Here.
Hochstetter?
Here.
Kenna?
Here.
Rinke?
Here.
Wilsey?
Here.
All members are present.
Thank you. So we have special business tonight for this special city council meeting, CIP 24-10 Hops Alley and Heritage Park Phase 2 change order. Deputy Mayor Elfers, would you like to make a motion?
Yeah, I'd like to make a motion to approve CIP 2410 Hops Alley and Heritage Park Phase 2 change order.
Can I get a second, please?
Second.
Seconded by Councilmember Evers. I'd like to call on Assistant Engineering Manager Drew McCarty.
Good evening. Thanks for coming in tonight, Council. If I haven't met you yet, my name is Drew McCarty, and I'm an Assistant Engineering Manager here at the city. Nice to meet you. The item before you tonight is a change order for CIP 2410 Hops Alley Heritage Park Phase 2 project. The city has worked to reimagine Reuben Canal Block Heritage Park as a more active, useful heart of the city for special events and everyday use. The city has been working to construct Phase 2 of the project to work towards activating the adjacent alley to Heritage Park, naming it Hops Alley to serve as a flexible event space and for a more accessible and inviting parking area for its daily use. In 2025, City Council approved a construction contract with Neely Construction in the amount of $2,943,884.51, which included a 10% construction contingency for a total authorized contract amount of $3,283,272.96. A change order is needed to incorporate work to improve the southern portion of Heritage Park into an interim usable condition while phases 3 and 4 are being planned. Considering previously approved change orders, the cost of the additional work would exceed the 10% contingency in Neely's construction contract that was previously approved by council. The attached change order modifies Neely's contract to pay for the additional work for the interim park. The current contract amount, inclusive of all previously approved change orders, is $3,283,272.96. This proposed change order increases the contract by $143,884.81, resulting in a new total contract amount of $3,382,157.84. These funds are within the previously budgeted cost of the project. Council has authorized previously $300,000 in 2024. We have used $70,000 and we are now ready to appropriate what is needed for this change order that you will see in next Q1 budget amendment. Included in your packets, there are a few pages with a plan of what the interim park condition would look like, with callouts on what would be included in the park, such as 3 dedication plaques on supporting stands, cleaning up of the existing asphalt area, and then additional seating and irrigation included in there as well. And if you have any questions on this, I'm happy to answer them.
Councilmember Elfers.
Deputy Mayor.
Oh, Deputy Mayor, thank you.
Jeez.
Thank you. You keep on me.
Might still have a green.
Yeah, I don't know why. Hit it again. Let's see what happens.
Went away. Put it back.
Let's see if we can get you. Just give us a minute here.
You can borrow mine if you want to.
No. Michelle, do you have control down there of these mics?
I'm showing that Deputy Mayor Elfers is on. His mic is on.
It says green, but it turned red. I'm good. Hey, thank you, Drew. I could have talked to you, but we got to be on speaker. So, yeah, thanks for doing this. Can you give me a couple clarification questions on this? This project initially was funded, I believe, by tourism funds and some grant money. Is that correct?
Is that better?
Oh, there you go. Yes.
Correct, yes.
Okay. and
So, oh, go ahead.
Yeah, and then this change order, is this is like this is a different phase, is it inside of that, or how does this connect with the grant funding?
Doesn't necessarily directly connect with the grant funding. It's just part of, in the same project area. It was considered phase 1 of our project, and we kind of jumped phases and went to 2 since we did have that LTAC funding for phase 2 of the project.
Okay, so this is coming out of the general fund?
Yes, it's coming out of the $300,000 that was already appropriated, or sorry, not appropriated, authorized back in 2024.
Got it, okay. And looking at the actual change order itself, I see just a couple of items, some additional square footage of concrete sidewalk and some pedestrian curb. That's only adding up to about 10,000. Is there additional information that gets to the 130, or is it more complicated than that? I'm just looking at the actual paperwork we have in front of us. The 170 square foot of additional concrete sidewalk for $5,400, an additional.
So those items, those are within the project itself. We have lump sum items and we've got unit price items within there. Within this change order, those unit price items were already pre-negotiated rates when the bids came in. So those are rates that we got for the concrete sidewalk. So we didn't have to get a new price with our contractor, and then same with the ped curb. So those two are dollar amounts that are changing the amount of the bid item within the contract and adding additional, square footage or lineal footage within those bid items.
Okay, and one more question. So does this get us the items we were talking about a couple of years or so ago? It gets us the pickleball court?
So this gets us with the contractor. So in-house, we are going to do a sport court material with our crews. But this gets us the fencing around the material, the dedication plaques, the big grassed lawn, and then a cleaned up asphalt area for us to be able to use adjacent to it.
Okay. And then one last question on the timing. So the contract is finishing up on the initial scope, and so this is important to keep them so they don't have to remobilize. Is that correct?
Correct, yes.
Thank you.
Councilmember Kenna.
Thank you, Mayor. Yeah, Drew, just a couple clarifying questions. So would this change order and the adjustments or the improvements within this change order, does that end phase 2 work essentially? Does that just get us up to a usable condition for the piece of the property that is phase 2, and then 3 and 4 are to be determined?
Correct. Yes, so right now, can you hear me?
Sorry, I think you went off. Oh, maybe.
Okay, so as you currently see the park right now, that's how it would be left without this change order. So this gets us to more of an interim condition until we can get to phase 3 and 4 and, that stage of the project.
Okay. Is there a reason, I'm sure there is a perfectly reasonable explanation, why a usable condition wasn't part of the initial contract to begin with, why we weren't shooting for that anyway? Is it just because we knew there was changing factors, we didn't know exactly what that might look like? Or? Exactly,
yeah. Changing factors and then funding as well, trying to make sure we could get, the north end and the alley as part of to fit in our funding that was coming.
Okay.
Like from the LTAC in Pierce County.
Okay. And so if we didn't approve this change order, then the park would really not be in a usable condition in the interim until phases 3 and 4 were planned and constructed? Okay, gotcha. I think, and last question I have is, in terms of long-term options and plans for phase 3 and 4, like we've talked about, any of the improvements that we're approving tonight, does that impact or kind of hem us in any way of options down the road with those phase 3 and 4, and at least the way we're planning it right now?
I don't want to touch it. Okay, there you go. No, so it would be all temporary conditions.
Okay.
Usable temporary conditions.
Okay, so we'd still be able to adjust things as funding allows or options change.
Correct. Yes.
Okay. Thank you.
Any other questions? Next on, Councilmember Ranky.
Yeah, I'll just say this came to the Public Safety Committee last week. All 3 members were present and recommended a do pass recommendation. Drew gave the same presentation. We had some of the same questions brought up also, and we were all in accordance with the do pass. So I recommend do pass recommendation from Public Safety Committee. Thank you.
Thank you. Any more questions? Okay, any comments from the public? Anyone on Zoom? Any additional comments from the council? Okay, will the clerk please call the roll?
Elfers,
Yes.
Ranky,
Yes.
Evers,
Yes.
Hochstetter,
Yes.
Wilsey,
Yes.
Canna.
Yes.
Motion passed.
Thank you. Okay, thank you very much. So just a reminder, the regularly scheduled study session will begin at 6:12 p.m. And since there is no further business before the council, this meeting is adjourned at 6:11 p.m. Thank you. All right.
And Mayor, we're going to need just a couple of minute recess to reset the room.
Thank you. I'd like to call to order the study session of January 26th, 2026 at 6:14 p.m. All members are present. Our study session business tonight is a council presentation from the WCIA, our city's insurance risk pool. We have City Administrator Jason Wilson and WCIA Deputy Director Rob Roscoe here with us. Thank you.
Thank you, Mayor Bowman. As you mentioned, tonight we're going to hear from Deputy Director Rob Roscoe. He represents Washington City's Insurance Authority, which the city's been a member of for several decades now, actually. So he's going to go through a presentation of who WCIA is, what they cover, and also some general guidelines that they pass on to newly elected leaders. So turn it over to Rob.
Thank you. Good evening. My name is Rob Roscoe. I am the Deputy Director of WCIA. I say WCIA, and initially people are kind of interested. Oh, WCIA was at Washington Central. And I tell them insurance, and they just glaze over. I lost them. I've been involved with WCIA now for a little over 26 years. I also apologize. My voice is probably a little rough. I was at an event the other day. Oh, yeah, a little minor thing, but yeah, great game. Anyway, so I'm a little bit recovering from that tonight, and you'll hear it in my voice, so I do apologize for that. Like I said, I've been involved with WCA now for 26 years. I've been in the insurance industry for close to 30 now. How'd I get so old? I still think I'm 21. I go all over the state of Washington for WCIA. We insure municipalities, but we're not an insurance company, and there's a really big distinction there. We are a interlocal government agency created by municipalities to insure municipalities. We were created in 1981 primarily because, believe it or not, government agencies are not a very good insurance risk. And back in the 80s, it was getting very expensive, very difficult to find coverage, and what coverage you could find was really restrictive, and you didn't have a lot of control or say in how things were being handled. So a bunch of cities decided to create their own risk pool and insure themselves. It's a way for cities to pool their monies together. What they can't do individually, they can do collectively. So that's when we came to existence in 1981. We were the first risk pool in the state of Washington, and we are by far the largest risk pool in the state of Washington, both in assets and financial coverages that we provide for our members. Have over 165 different members throughout the state of Washington. So I do this presentation all over the state. I go up north to Sumas, I go down south to Camas, Washougal, the Tri-Cities, Spokane Valley, all over the state. But I gotta say, this was my best commute. Literally took me, I think, 10 minutes to get here. So I live locally, I'm just up the hill. My mother-in-law lives in Sumner. I grew up in Edgewood, went to Puyallup High School. Still a little bitter about that football. Yeah. Anyway, congratulations. Very happy for Sumner. Great game there too. So I'm very invested in the community as well. Some of the advantages of being in WCA though is the insureds really own us. We are owned by our members. We are directed by our members. You get to have a voice in how we operate. Your city administrator just got elected to our executive committee this past full board meeting, so congratulations to him. So he is now serving on our executive committee. Give you a little bit of background on myself as well. I worked for WCA in 2000, 2005. I left to go work for an insurance company, but got recruited down to a local municipality, and I was there for 12 and a half years. So I know what it's like to actually work for a member of WCIA as well. So I worked for a member, I was on the executive committee, and then I got recruited back to WCIA to be the deputy director. So I understand what it means to be a member, as well as provide the coverages for the members. But the nice thing too is we don't underwrite. I don't underwrite to try to make money off of our members. We underwrite to cover our costs, and it's getting very difficult to do that. And I'll explain a little bit in the presentation as to some of the factors that are driving those costs, just so you're educated on why we charge what we charge, because it's very difficult these days. But we also pride ourselves in providing a lot of training and resources for our members. We don't tell you how to run the city of Sumner. That's your job as elected officials, that's staff's job to provide those programs and those services for your residents. We're here to educate you about the liability exposures with the services that you provide, make some recommendations, some suggestions to help reduce those liability exposures. So if something were to go wrong, we're in a better position. One, hopefully nothing goes wrong, and we're providing you with tools to prevent those things from happening. But if they do go wrong, we hopefully can either defend or pay for subsequent damages that are a result of that. So we have a lot of risk management advice that we provide to staff. We do a lot of trainings throughout the year that staff can register for and attend, and they're free to our members. Because again, you pay an assessment, we provide these services back to our members. We try to keep our rates as stable as possible, and I have a slide that kind of talks about that in the upcoming presentation. It's been really difficult the last 10 years. I'll be honest, it's been a brutal market out there, especially in Washington State. The other nice thing is when you have claims that come up, I can tell you firsthand experience because we've had to sue our own reinsurers to recover monies. When there's large damages that have to be paid, the first thing they're going to do is look to that insurance policy, look to the exclusion page, and see what, if anything, is covered or uncovered. And if they don't have to pay, they're going to find a way not to pay. We don't operate like that. We look to try to find coverage for our members. We're owned by our members, so we want to make sure you're having the best coverage available to you. At the same time, we also have a fiduciary responsibility to the entire pool as well. So we can't just pay arbitrarily. We have to make sure there's some basis or nexus for that coverage within the coverage document as well. Also, if you have any questions, last thing you want is for me to speak for an hour from the insurance guy. I'll be honest, I'm not that interesting, as you can probably already tell, especially a Puyallup guy, right? But we are not an insurance company. We provide insurance services. We're a risk pool. So we self-insure the first $4 or $5 million now for any liability claim. Then I have to buy what's called reinsurance up to $20 million. So you have $20 million with liability coverage for the city of Sumner. Then we also insure your property and your autos for auto physical damage. So if you were to have, well, after the atmospheric river flooding or any fire or vandalism, probably from those county kids coming in, no city kids would ever do that. But if you had that vandalism, that's where we would come in and pay for those damages above the city's deductible. For property insurance, we provide up to $400 million. $250 million in earthquake and $175 million now in flood coverage. So you have some very good coverages with us. Yes?
So talk about deductible. I'm familiar with how it works.
There you go, Councilmember Evers.
Thank you. Oh, I'm sorry, I should have buzzed.
No, you're good.
I wasn't sure what study session the rules were different or.
No, you just do that. I'll
Okay.
put you over here.
I think I forgot what I was going to ask.
Deductibles?
No, deductibles. So this is a risk pool. So
Yep.
do we have our own deductible as a city, and then is there like a deductible within all the cities of the state as well?
Sure, I can explain that. For liability, you have $1 coverage. So there is no deductible from a liability perspective. For auto physical damage and property, we do provide different deductible choices for our members to choose from at different pricing levels. So typically, most cities have like a $1,000 auto physical damage deductible and a $5,000 property deductible. That seems to be pretty standard for most municipalities, especially the size of Sumner. You bet. And the other coverages we also provide are, like I said, the property, the auto, boiler equipment breakdown, cyber liability, as well as crime and fidelity. If there's any internal theft of city resource monies, we would provide that coverage for you. We group purchase those for our members. I don't directly insure the cyber, the premises pollution liability, or the equipment breakdown, but you get the benefit of that group purchase from 165 different members with all the assets that we provide. We have very good rates for those. As I mentioned, insurance, it's a very cyclical industry. You can see rates go up and down depending on the markets, their own losses. Property for the longest time was really bad. I was seeing huge double-digit increases. Some were not even getting renewed because of wildfire, flooding, global warming. All these catastrophic risks impact the marketplace. Good news is the last 2 years, I've seen the property market soften. What we say by soften means rates come down, coverages are more available. I get more carriers interested in wanting to insure us. And with us, I have over $17.8 billion that we insure throughout the state of Washington. So we have a big market for coverage. And the good news is last 2 years, we saw some rate reductions. So that's nice. That doesn't necessarily mean every member's going to see a rate reduction because then we get to have to pass that along based on actuarial studies as to where individual rates will flow. And we try to keep rates stable, so we try to buffer the membership with, when we have large increases, we don't directly pass all those costs directly on to our members. At the same time, if we see a decrease, we're not going to see that large decrease as well. We're going to try and keep it as stable as possible because we understand you have budgets. You're trying to budget on a year or 2-year cycle, and you want some kind of certainty or assurance of where rates are going to be. So we do the best we can to try to keep those as stable as possible so that you can budget accordingly. Liability, though, it's the opposite. Liability is an extremely hard market. Washington State, unfortunately, is one of the worst states in the nation from a liability perspective, and I'll go over a couple of factors as to why that is. Primarily, we don't have any sort of tort caps, so the sky's the limit. A lot of states have in their, as far as damages go, the most you can recover for any type of damage would be X, Y, or Z. Washington State does not have that. We also have what's called joint and several liability, which is kind of a deep pocket liability scheme that I'll talk about later in the presentation, but it makes you definitely a target for potential plaintiffs to try to collect from because there might not be enough insurance to cover the damages from that individual that was harmed. So they're going to look to any other resource or pocket to be able to collect from, and unfortunately, sometimes that is going to be the city of Sumner. So you will get named in litigation, and that's where we come in to provide defense and indemnification if we have to. Back in 2022, we had 2 very large reinsurers leave the state of Washington. They basically said, no more, we can't do it. We're not offering any coverages anymore, and those were 2 reinsurers that I happened to use. Because again, I insure the first $5 million, then I have to buy reinsurance above that to that $20 million layer. And when they pulled out of the market, that left a really big hole that we've been still trying to fill. We do have some good carriers that long-term partners that we've been able to backfill those with. But just to give you an example as to how bad it is, last year we insured the first $4 million. This year it's $5 million because my primary reinsurer told me I had to increase my self-insured retention level to $5 million because it was too expensive for them and they needed us to have more skin in the game, so to speak, on those losses. So they provided me with $5 million in reinsurance coverage above my $4 million up to $9 million. Now they only provide me with $3 million above my $5 million. That gets me to $8 million. So they pulled back their capacity because the risk is too great, and we've had too significant, or we've had to pay in too many. They had to pay too many losses, basically. So they cut my capacity down. I've had some new carriers come in that would backfill that, but it's just a struggle. Every year I have to go and meet with carriers and explain to them our programs, our pools, and why we're good a risk, why we're a good risk, to get them to want to write us, and it's harder and harder every year. I go to Lloyd's of London primarily for the property coverage because they're a large enough syndicate. Lloyd's of London is not one insurer, it's multiple carriers. And I have a lot of carriers because we have, again, $400 million and we insure over $17 billion in assets. And I also met with them with liability. And you think of Lloyd's of London and they insure everything. They told me no. That's how bad it was from a liability perspective. They would not underwrite us. In the last 10 years, my rates have gone up over 700%. I used to pay 5 cents per 100 hours for employees, worker hours. We use employee worker hours as our rating basis. Now I'm paying over 41 cents per worker hour in just over 10 years time period because of the market. So we try to keep them stable. We don't like to pass those costs on to our members because we know the impacts it has in your ability to provide the services to your residents. No one wants to have to pay an annual insurance bill. I don't like paying my homeowners or my auto insurance. It's just the cost of doing business, unfortunately, in today's society. And cost of doing business in Washington is getting harder and harder from an insurance perspective. We've tried talking to the legislature about some tort reform. There's actually a House bill now that we sent out that they're looking at trying to get rid of some third-party funding where you have third parties that are actually funding plaintiff litigation as an investment vehicle. So we're trying to eliminate that because that just increases costs to everybody involved in that. But for the most part, I don't see a lot of headway or a lot of traction in the legislature. In fact, it's usually just the opposite. They have a very well-funded plaintiffs' bar that contributes a lot of campaign dollars to the legislature, and it's an uphill battle for us. But we will continue to fight the good fight and speak wherever we can speak about liability reform because we do think it's important. Because these are dollars that come out of general funds for a lot of situations, and that prevents you from providing those additional resources.
We have a question up there
Yes,
for you.
of course.
So Deputy Mayor Elvers.
Yeah, thanks, Rob. I appreciate it. I guess one of the questions I have is, so you're looking back to 2022 in Washington, and you said Washington specifically has changed. Do you have any specific, specific things like laws or policies or something that in Washington that changed that resulted in a lot of the additional liability, or what?
Well, what's really doing it is the large verdicts. We call them nuclear verdicts, verdicts over $10 million. I have some headlines here that are just from the paper. State of Washington had to pay close to $100 million with the Susan Cox Powell tragedy with her 2 children. You may remember that. Got national headlines. Had to deal with Department of Social and Health Services. They had court-ordered visitation with their dad, and unfortunately were brutally murdered by the dad. And they sued the state. And part of the allegation was, well, you shouldn't have taken them to the home. Well, this was court-ordered supervision. You know, no one could foresee that tragic event, but it turned into a $100 million lawsuit. We thought that that would be a catalyst to spark discussion, at least, for some tort reform. They just did a budget amendment. So that's the difficulty that we're faced with. And it's very hard to argue against those tragic events because no one wants to see a loss of life. And how do you put a dollar on that? You really can't. So I get the damages side, but it's not supposed to be punitive. Punitive, there's a different form for punitive damages, but a lot of times they escalate those damages and it turns into kind of a punishment situation, even though it's not supposed to be a punitive damage scenario. It's just supposed to be general damages.
So as far as, can I just restate that my understanding what you're saying is that there's been some big verdicts because of some things that have happened, and
Yes.
they have been not necessarily, in this state, you think a state would kind of try to correct that to create some, so the verdicts are more reasonable, and they haven't done that. Is that what-
There's a lot of things. There's the tort reform basis are third-party funding and looking at like the non-economic damages. And the biggest thing for Washington that we see is we have what's called a modified joint and several liability allocation, where if you have a negligent-free third party and they are damaged by 2 or more people that are at fault, they can sue both parties and collect the entire judgment from either party, regardless of the amount of fault attributed to those individuals. So if you're at least 1% at fault and you have someone that is fault-free, they can collect the entire judgment from that 1% at fault person.
Okay.
So that comes into play a lot with, unfortunately, road design, where you have a passenger in a vehicle and a car is involved in a bad accident, and there's not enough insurance to cover the damages associated with that accident. So they're going to start looking to find fault with whatever party they can. It could be the driver, but it could also be the municipality or the county or the state whose road they were driving on. And if they can show that there was at least 1% at fault, then they can collect the entire judgment for their damages against that individual. And we can't argue to a jury in their deliberations that if you find them at least 1% at fault, you could be holding them entirely accountable for the damages because that's prejudicial. So we can't even argue that when we go to court and explain that to a jury that by finding them 1% at fault, you could be holding them 100% accountable.
Got it. Okay. So you're saying that okay, I think I'm understanding you. So the way that you're talking about the way that tort happens is just not very equitable.
No, not in our state. And we are one of the few states that have joint and several liability. I think there's 7 in the nation, and we have a modified version where at least you have to be fault-free. So we have that element of it, but it's pretty easy when you have a passenger or child involved. And we had, unfortunately, a drowning at one of our members, Town of Steilacoom. It was in the paper. It's part of the headline I showed. We insure Town of Steilacoom. They went to Anderson Island. They dropped some kids off, 14 to 15 years old. It was an adventure park, it was called Adventure Program. Parents signed waivers, releases. Unfortunately, you had to take a ferry to Anderson Island. They dropped the kids off, literally a 5-minute drive to and from the ferry dock to the lake. When they had to make 2 trips, and they left the children unsupervised. And in 5 minutes' time, unfortunately, a child jumped into the water and drowned. And it's tragic. My heart goes out to the family. No one wants to see that happen. But the town was then liable for $15 million. So that's where it's so difficult to underwrite and insure municipalities when you have that specter of a judgment. How is a carrier ever going to recover that type of money? They're not. So that's where it's a hard insurance risk.
Got it. Okay. Yep. So insurance, yeah, because they can't really tell how much the risk is. So they're like, we're just going to make sure we buffer our rates so we don't lose money. Okay.
Exactly. Or they don't offer it. But realistically, that's why WCIA exists. We exist because the insurance market hasn't been there for municipalities. So that's why we were created. So I can gripe all day long about it, but it gives me a job. And this is what we do. And we're here to train our members about these exposures so that they can make those educated decisions so that they know you cannot leave kids unsupervised, even for 5 minutes when there's that risk to them. So that's the training that we provide throughout the state and the services we do. But you can see, per capita, Washington is the 3rd worst in the state from a liability perspective with juries and jury verdicts. So it's that dangerous. And this kind of shows you the cost that we have. This is actually Sumner's annual rate increases. And you can see there have been some spikes. We had to raise our rates, unfortunately, because of the cost for insurance and those verdicts and indemnification. So we don't like doing it. We don't want to do it. We'd love to see these rates come back down and give you more money to provide those services for your residents. But we have to cover those costs and keep operating for all of our members. So let's talk about council and your roles and what you can do to help reduce your own exposures and liabilities as a elected council member. Good news. Actually, you have some pretty good defenses. We don't see individual council members being sued significantly anymore. We used to. Back in the early 2000s, we'd see a little bit more of it. But we got some good defenses, and there's some good immunities out there when you're acting as a council as a whole. So when you're acting as a elected legislative body, we have good legislative immunities, discretionary immunities for your decisions, and good defenses while you're making those decisions. It's when you step outside of that role and you start acting as an individual that you start creating a little bit more of an exposure. When you send out correspondence from the desk of or offering your own individual opinions or comments that aren't the council's as a whole comment or what the council thinks. Once you start acting individually, it creates a little bit more of an exposure for us. It's not unsurmountable, but you have to be aware of it. So we always say act as one body, as a council, as a legislative body, and stay in that context. When you step outside of that, you create a potential exposure that we have to then try to defend or offer a defense for. Land use is one of our biggest exposures, unfortunately, because it puts council in a quasi-judicial capacity. And that's a tough role because you hear from a lot of residents. Do you guys use a hearing examiner?
Yes.
Thank you. Thank you, thank you, thank you. Appeals go directly to Superior Court? Yep.
Yes.
Okay, that is probably the best advice I give councils is to extricate yourself from that process because you have to act as a judge in a quasi-judicial role, and you hear from a lot of residents. You hear from public. You hear public comment. But when you have land use issues, you have to rule on what's in the record. And sometimes those comments and those public comments are not in the official record, and it could lead to a bias or an appearance of unfairness or arbitrary or capricious decision-making. That's where we get into those litigations. But again, for the most part, well insulated, and that's a great risk management tool that we usually recommend all our members follow and use a hearing examiner for that process. Caution a little bit about development agreements because those are contracts. And development agreements are a creative way sometimes for municipalities to do a little bit more with their code. But I caution you because it's a contract, not a civil tort. So we don't provide any sort of indemnification or coverage for breaches of contract. That's outside of our scope. That would be something you have to follow as a party to that contract. And I mention that because you may know we have a particular town of Cle Elum right now that's struggling with just that issue. They had a development agreement turned into a $22 million loss. We were involved in that initially. And actually we had some coverage that we did provide the city for that. But again, it's one of those things that can snowball and get very complicated very quickly. So be very careful, because it can bind future councils as well. So we tell our members to please make sure you seek good, sound legal advice through your city attorney's office and make sure you understand all the intricacies of those agreements before you utilize them. Personnel, this is where I get a little scared straight speech. You're the legislative body. You have an executive, you have the mayor, you have a city administrator, you have staff, you have directors, you have department managers. Let them deal with personnel matters. You do not want to insert yourself into personnel matters because it can get very complicated very quickly. There are a lot of laws that were passed and designed not to protect the city of Sumner, but to protect employees and employee rights. And you have to be familiar with those. And what's legal today may be illegal tomorrow because a lot of these are interpreted through case laws. They get evaluated through trial and error sometimes, and that's where it can be very complicated. And that's why I say let the Human Resources Department, let the city administrator and the mayor deal with the executive side of issues and don't insert yourself in there. The other thing is, if you are counseled and told to please refrain from acting in a certain way or using certain words or comments, take that to heart and don't argue about whether or not it's offensive because your intent is irrelevant. It's not what you intended, it's how it's perceived by those that are impacted by those words or those comments. And we've seen some situations arise where council may say, good night, ladies. Well, it seems innocuous, but if you're always using gender-specific terms or girls, that could be offensive to a group of people. So if you're told to please refrain from doing so, don't argue about the offensiveness. Just please, please, please stop doing that behavior. We provide the $20 million to the city of Sumner, the elected officials, employees, and volunteers, as long as you're acting within the course and scope of your duties for the city of Sumner. Do not look at the employee directory as a personal Tinder profile list and start asking staff out. You laugh, but I wish I could make this stuff up. It happens throughout. I've been doing this for too long and have seen too much. But it is very difficult. Your words carry weight with staff. They want to please elected officials. They are somewhat fearful that you could terminate their employment. So you come from a position of power and authority, and you do not want to engage in that type of behavior with staff. And then if you're told to stop and you continually ask an employee out on a romantic relationship, that's where you could start crossing the line of acting as an individual and not acting in the course and scope of your duties for the city of Sumner. That's where we then remove our indemnification, because we don't protect you as an individual, we protect you as an elected official. And when you're acting in that individual capacity, you could be on your own. And we have asked courts to dismiss us from having to defend and indemnify people acting in that capacity, and they've agreed to do so. So it's a high threshold, but we have been able to get ourselves removed because it's clearly outside your roles as a council member. And you're told to stop and you continue to do so, then now you're not acting as a council member. You're acting as an individual, and your own personal assets could be at risk. So that's where, if you're told to stop, please do so. If you see something, please report it. If you see inappropriate behavior, if you see staff being subjected to inappropriate behavior, please let the mayor be aware of that, or the city administrator. They have affirmative duties as the employer to intercede and make sure that they're protecting employees, and you are the city of Sumner. So if you see something, please make sure you report that as well. Negligent misrepresentation, don't say, oh my gosh, I'm so sorry, we'll take care of it. You may be well-intended, may be well-meaning, but again, your words can carry weight. You don't want to make any sort of promises or assurances that the city's going to take care of things. You may not be responsible. We have to do an investigation into that. If you start telling people that you'll take care of it, and they rely upon that to their detriment, that's where we can come into play. We had one situation where there was a certain town that has or a city that has some pretty strict downtown ordinances about what businesses can put on their buildings, siding, what have you. Joe calls up the mayor and says, hey, Mayor, I want to put stucco on my building. Is that a problem? Joe, that'll look great. Go ahead and do it. So Joe gets his contract in place. They're out there putting stucco on. Code enforcement comes by and red tags them. That doesn't meet our downtown code. You can't be doing this. Is that a problem? Yeah, it's a big problem. I get the claim, call up the mayor, say, Mayor, did you tell Joe he could do that? Yeah, I did, Rob. Well, Mayor, I now have to pay for that. That's where your words can carry weight. So please be careful about that. Don't be afraid to direct them to staff. Direct them to the proper department. Public Works, Planning, Community Development, Maintenance and Operations, whichever department it may be, don't be afraid to say, here's the number to them. You may want to talk to staff. Let staff do that. That's what they're there for, to help those businesses and your residents. Defamation, you have a big voice while you're up there. You have a lot of meetings, public meetings, and you want to be careful specifically about naming individuals. You don't want to refer to people as slumlords. They may have some property in disrepair, but you have a process for that. Code enforcement can go out there and deal with those issues, but you want to be careful about not defaming individuals. Now, elected officials, it's a little bit higher of a threshold. As an elected official, unfortunately, you have to have thicker skin. And obviously, any untruth can give rise to liability. So just be careful about your words that you're using in a public manner, especially in your official capacity. I do have to talk to you about the public works, or I like to call it politically engineering. This is where joint and several really comes into play. I kind of talked about that earlier. Because you'll get a lot of suggestions from residents in neighborhoods about speed limits, speed bumps or speed humps or signage. They see perceived problems and supposed solutions, and they want you to do certain things. But you have to be cognizant that anything you do on your roadways is a system. It should be engineered. These turn into engineering malpractice cases, basically, when there's not enough insurance to cover the damages and someone's significantly injured, they're going to look to say, where can I recover that additional money from? Well, you have $20 million in liability. The car only had $20,000 in liability coverage. Well, that paid for 2 hours of an attorney. So obviously they're going to come to you as that deep pocket. So you have to be very cognizant that your words and what you're saying about your roadways can inflame damages. In particular, I had one council member that was adamantly opposed to traffic circles. He hated them, didn't like them, thought they were unintuitive and a waste of time and money. So he referred to one constantly as the circle of death. Yeah, again, I don't make this stuff up, in his jurisdiction. Now, if we ever have someone that's significantly injured there, do you think those words are going to come back and bite the city? Yes, because they're going to inflame damages saying, look, you knew this was a problem, yet you failed to remedy it. Where logistically it wasn't a problem, it was properly engineered, it met MUTCD, Manual for Uniform Traffic Control Device standard, AASHTO standards, it met all the criteria as a well-designed traffic circle, but because you use those terms, I now have to depose that council member in court and ask him where he got his traffic engineering degree at. Oh, he didn't, and it was just an opinion. And we don't want to have to do that to council members. We don't want to have to depose you and ask you where you got your traffic degree from or traffic engineering degree from, because we know a lot of them don't have them, and it's just that, an opinion. But by using those words, it can create a perception of a problem. So sometimes it's well-intended. No one wants to see anyone hurt on sidewalks, streets, roads, playgrounds, parks, what have you. But if you refer to it as being unsafe or dangerous, a lot of times that's an opinion. And it may be perfectly safe. It may meet the proper criteria as to why it was designed the way it was. But by using those terms, you're inflaming a plaintiff to try to claim that there was a problem there. And then we're going to have to try and depose and defend those against that. So we have had some problems with those politically engineering decisions because, again, when you say, let's put a traffic sign here, but the warrants don't justify it, and then you do put a traffic sign there, or stop sign. Next thing you know, you have traffic backed up for 2 miles on all the other intersections where you had 50 people complaining, now you have 500 people complaining. We've seen that as well. So just be cognizant that you have traffic engineers. They can do traffic studies. They can look at those issues. That's appropriate. They can study it and see where problems need to be remedied or fixed. And then as a council, you have immunity or discretionary immunity for the decisions you make. You only have X amount of dollars in your budget. But if you need to make improvements, you can allocate those monies accordingly. But that's where you have to work as a group during the budgetary process. That's your role as a legislative body, is to look at those budgets and make those recommendations where they needed to be made. But again, avoid those promises and assurances, because that's where they always come back and get us later. Executive session, this is a great tool. This is one of the few times you can have some frank discussions over personnel matters, contracts, union contracts, collective bargaining issues, real estate transactions, or potential pending litigation. So they're a great tool for you, but you need to keep what is said in executive session. Do not talk about it to your spouse, your significant other, your neighbor. There may be some entertaining stories being said, but you don't want to share those stories with outside people. I've had situations before. Well, I worked at a municipality. We've had a council member that was leaking information to the press that they had to censure her over. So that's where you guys have to govern your own conduct and your own behavior through your council rules and procedures regarding that. I've been in situations before, though, where we give litigation updates to council members regarding claims, pending claims, and trial notifications, and we talk to them. And we're going to go to a mediation, and I disclose to them where we think this claim is going to settle at. Well, when we go to mediation, we're trying to mediate and give them a fair, equitable settlement if we feel that there's exposure there, but we also want to be reasonable with that. And we had it where the other side knew my dollar amount. They knew how much I had authority for. The only reason they knew that was because we had a council member that was leaking that information to the plaintiffs, because they were very sympathetic. They knew the family. Now, if I find out about that, guess what? I'm not going to include you in those discussions then, and we don't want to extricate you from it. We want to make sure that you're aware of how we're operating and where we're proceeding on these areas. But if we can't trust that it's going to remain in executive session, then we're not going to come and talk to you about that. So be very cognizant about that, and you don't want to breach it at all. Keep it in exec session. It's more sacred than Vegas. You know what they say. It goes on in Vegas. What goes on in exec session has to stay in exec session. You work as elected officials. First of all, thank you for your service. I know it's a lot to be an elected official. My sister-in-law is Mayor Fife. She's been the mayor down there for a while. I used to have to go to council meetings all the time. I know how much work it takes to be prepared on these issues. So thank you for that. But you also work in a fishbowl now. Everything you do for the city of Sumner is a potential public record. Every email you send on as an elected official is a potential public record. So you do not want to mix city work with your own personal computer or cell phones. I have 2 cell phones. I have my WCI cell phone and my personal cell phone. I'm a government employee. I'm a public employee as well. We're an interlocal government agency. I don't use my WCA phone for personal business, and I don't use my personal phone to conduct WCI business. Because again, it is a potential public record, and you have to produce metadata. The public record laws are very complex and very demanding on the city to have to reproduce those records on demand. And if you're mixing that up and you're not being able to reproduce that data accordingly, it can present problems with fines and penalties for the city. We don't indemnify our members for public records because it is a fine and penalty. So it would go against kind of public policy if we were to indemnify and pay on behalf of our members for not following the law. So you're supposed to follow the law, and you'll get fined and penalized if you're unable to reproduce that data. But that's where you have a city attorney. She can educate you if you ever have any questions regarding proper public record etiquette and what is and what isn't a potential public record. Some things can be excluded. There are a lot of exemptions to that, but they still have to reproduce that and show an exemption log. So it's very onerous on staff to have to reproduce this stuff. So that's why you want to keep your city business on city-issued equipment so that they can reproduce that information. I actually had one member that was suing a council member just for that issue. So the city was going after, because he was refusing to do so. And that created a problem then for the city from a public records request perspective. So be very cognizant about that. Also, emails and reply all, especially with the Open Public Meetings Act. You have to conduct business in the open. And if you have an email that's discussing city upcoming ordinances, resolutions, you don't want to ask how people are going to vote. Be very careful about forwarding emails. You can create a public meeting violation very easily, and that's where your city attorney, again, can be your best resource because that can issue a fine and penalty as well. Now, if you use social media, be very careful about crossing lines on your personal rights and that as a elected official. If you have a council member Facebook page, stick to city business. Don't mix that. If you have a personal page, don't conduct city discussions with residents on there. If you open up communication and create a forum, a potential public forum, it's very easily to violate First Amendment rights, especially if you then try to censor or ban people from commenting on one of your public forums. We've had that situation before where we had some very offensive material that a council member allowed through public comment, and then they tried to block them and censor them. And lo and behold, that violated his First Amendment rights. So we had to pay on behalf of that from a First Amendment violation perspective. So be very careful about that as well. With that, I think I'm good, unless you guys have any questions for me regarding what I discussed.
Okay. Councilmember Kenna.
Yeah, Rob, that was super comprehensive. Thank you so much. Feel very well informed. Go back a couple, you don't have to go on your slides, but just
Sure.
a couple of slides ago, you mentioned city budgets.
Yes.
And decisions we make in terms of, if we have somebody talking about the circle of death roundabout or something like that, and keeps harping on that and what, that does for our liability. I'm curious though, like when we make decisions as a council with our budgets to fund a certain project, let's say staff are saying, hey, this is a problem area, this sidewalk, this road, whatever, we need to address this, it's a safety concern. And we as a council may decide, that's not in the budget for this term. We'll look at that down the road, and something happens. How do those budget decisions and those priorities that we as a council make impact liability in terms of that?
Sure, that's a great question, and it's very complicated because every claim has to be evaluated on a case-by-case basis with the facts and a review of that. But in general, you have some immunities for your decisions that you make as a council where you allocate monies. That doesn't mean the city's not going to get sued as well. And if there are dangerous situations out there, unfortunately, we don't live in a nice flat level environment. We have hills, we have tree roots, we have things that can create problems. We try to mitigate those and eliminate and reduce the risk of harm to third parties through taking actions that staff can do, like highlighting things with red or fluorescent paint, what have you, to minimize that to the best of their ability. Now, does that mean you're not going to get a claim? No, you probably still are, but our ability to defend you is going to increase if you're following those best practices and that advice. And if you're allocating your budget accordingly, how you think it's appropriate and what you fix and what you don't fix, and prioritize that, that gives us the ability to defend the city as to why it wasn't done. So that's a tool that we use in that pending litigation to get or try to defend and get the case dismissed. Now, ultimately, it could be a question of fact for a jury to decide whether or not it arises to that, because unfortunately, one of the problems we see is judges don't like to dismiss cases, and they really hate immunities and defenses, and they want things to go to trial for a jury to decide. When you go to a trial, it could be who's the better debater and who does the jury empathize with more, the municipality or the victim. So that's kind of those uphill battles that we have to struggle with as an organization as to what we pay and what we don't pay. But at least it gives us the ability to provide those defenses when you're following that.
So basically, it's a complicated answer, but, as long as we've got our ducks in a row with what staff are doing, the engineering, the safety, the planning, and all those types of things, decisions we make, there's still some protections, some options down the road, but it doesn't completely
It
absolve us.
helps us in the defense of those, but it may not eliminate everything entirely, unfortunately.
Gotcha. Thank you.
Anyone else? All right, well, thank you so much, City Administrator Jason Wilson and WCIA Deputy Director Rob Roscoe. A lot of great information.
I appreciate your time.
It. Thank you.
88. State champs that year. So that was the last one we won. 87 we won.
Married an 86
Ah.
All right.
Still bitter about that loss, though.
With that being said, we have no executive session tonight, so I will adjourn
Mayor?
this. Yes.
I'm sorry, if I could just remind the public as well as council, we have no meeting next week. It has been canceled. So your next meeting is February 9th. It is a study session with joint training with the Planning Commission.
Thank you. Thank you. So I'd like to adjourn the meeting at 7:05.